You've had an outstanding career exclusively in the field of commercial litigation. What's the key to operating successfully in this area of the law?
To be honest, I don't know how different it is from other areas of law. It's a matter of being able, in this area, to master complex documents quickly, to have a base of knowledge in the area of law, and then you just have to perform every single day, because no client cares that you won a case for a client the day before. Every single case is of critical importance to that client. So it's a matter of the Energizer Bunny attitude toward the practice of law. And I've got a bunch of great colleagues here which make the practice enjoyable and rewarding.
If I may quote from the National Law Journal, your firm has a definable sweet spot in big dollar, complex financial transactions. So how do you navigate complexity when there's so much at stake?
It's only when there's a whole bunch at stake that things get complex, because nobody can afford to litigate complexity in anything other than big dollar matters. That's the kind of case which requires a few skills. It's the ability to understand, it's the ability to communicate, and credibility, personal credibility, is actually the most important aspect of it, because you've got to explain to a judge, a jury, or an arbitrator exactly what's going on. It's going to be a lot of work for them to understand what's happening. And if they detect that you're engaged in double talk or being less than completely candid with them at the time you're going through all this, they'll be furious with you at the end, and it will redound to your disadvantage. And I see that happening a great deal. I find it highly beneficial when you can detect that on the other side.
Of the recent victories the firm has won, and there are many, which would you pick out as being of particular interest?
Well, we have one that's on appeal right now in the Second Circuit Court of Appeals. We won a $268 million judgment for Citibank against Morgan Stanley. The documents are mind-numbing that this document arises out of. It's a credit default swap, which depends on a lending agreement which refers to an indenture. So there are several hundred pages, and everything boils down to the meaning of the word consent. After you've gone through all of this exercise, and we had a very distinguished federal judge issue 3 opinions ultimately concluding that our position was correct. The Second Circuit will be considering it. But it's that kind of case that we really enjoy, where there's a lot at stake. You can afford to go all out to analyze and explain these documents, and it's the sort of thing that you have to help the court along with, because nobody is inherently interested in a credit default swap. This is not a salacious murder. This is something where there's a lot of money at stake, but there's no inherent interest, so you have to pique the interest of the court.
If you reflect on your years of practice, how do you think the area of commercial litigation has changed in the US in that time?
It's changed dramatically. When I started in 1975, cases were tried to juries, and the first 3 years I tried 30 cases. The last jury trial I had was now in 2007. Everything in contracts is switched to court trials or to arbitration, so there are numerous international and domestic arbitrations, but there's a great fear in the United States of juries. I also think we have a highly sophisticated bench, and the more they see of these issues, the more they're willing to enter summary judgment without going through to trial, and they find that to be a legitimate way of addressing complicated areas.
So building on your years of success, what next for you and for the firm?
That's always hard. It's whatever the next financial calamity is. We're always interested in what is going on in the financial field. One thing I do find is that lawyers in these transactions have become targets. So we find that we actually are now representing a number of significant law firms who are engaged in major commercial transactions as advisors, who then become defendants in, say, a $300 to $1 billion lawsuit themselves. And unlike accounting firms and corporations, there's not a great deal of experience on law firms as defendants, so they're perceived as ripe targets. So we do see more and more of that coming in right now.
Gregory Joseph, thank you very much.
Thank you.